Okay, good afternoon, everybody, and thank you for joining us this mid-October on another one of our quarterly updates, which are aimed specifically at in-house counsel and HR professionals. We're looking to recap this time on developments in the world of commercial contracts, data protection and business immigration. And as you'll probably know, there has been quite a lot going on, particularly in the worlds of data protection and immigration. So there'll be quite a lot for us to cover. As ever, if you've got any questions, please just let us know, and we'll try and answer those at the end. And if anything does come up which you want to think about in more detail, we will be sending out a recording of this, so don't worry, it will be coming out at the end. So thanks for that, and given what we've got to cover, I think we can move on without further ado to my colleague Rachel Atherton, who will be recapping and taking us through what's new in the world of commercial contracts. Rachel.
Thanks, John. Could we have the next slide, please? So as John explained, we're going to give you a bit of an update on case law, data protection, and also immigration for business. Next slide. So that's our team. You can let me know if you want in the comments whether the fringe or the non-fringe is better. Or we could just talk about some law. Next slide, please. Okay, so I'm going to talk about a couple of cases today that have been reported that I thought were quite interesting, and they've certainly had a little bit of an impact on areas of my practice. I'm going to look at a sale of goods, a case on the sale of goods where there was no price specified, and decide whether or not it was a contract or an agreement to agree, and also a couple of cases on third-party rights. Could I have the next slide? Thank you. So the first case I'm going to talk about is the sale of goods one, and it's KSY Juice Blends UK Limited and Citrasuco GmbH. So I've summarised the key points and the key facts on the slide, but I'm going to talk about it. So hopefully the summary is useful, and I'll try and discuss in a little bit more detail about what I think it means for practice. So the facts of this case are as follows. In 2018, the parties entered into an agreement whereby KSY, who's the seller, agreed to supply a quantity of washed extracted soluble orange solids, otherwise known as WESOs, to Citrasuco for 3 years. Now, WESOs is a product which is usually used in orange flavoured products, like food and drinks. And the contract was for 1,200 metric tonnes per year for 3 years. And there was a notional invoice price, which was €1,600 per metric tonne for a specific concentration. The pricing mechanism is quite specific to the market. It's quite complicated. But I suppose what we need to think about here is that it was subject to an adjustment if the concentration level was different. And they'd fixed the price for the first 400 metric tonnes per year, but not for the remaining 800 per year, which was, quote, at open price to be fixed latest by December in the previous year. And then pricing corrections were to be made by giving 3 trucks worth of the product. So that's how they, that was a price control mechanism. And there was quite a lot of, they had to have expert evidence on all this because it's quite a technical area of how these things in this market are priced. The contract said that an invoice was to be provided on delivery and was payable within 7 days. But Citrasuco decided that it didn't need as many or as much WESOs as it thought it had, so it started refusing delivery and didn't pay. So KSY brought a claim to have its invoices paid or to get damages. The legal question was whether there was a binding contract or whether because price hadn't been agreed, it was an unenforceable agreement to agree. Now, I certainly come across this in practice where, you know, people can't always fix a price over a long period of time in a supply contract. And there is always that risk, isn't there, that if you can't agree something as fundamental as the price, have you even got a contract in the first place? And that's really what this case is about. So there were two prior contracts between the parties before the one in question, and each of them had similar provisions to this one. So there was to be delivery of an amount at a set price, and then delivery of another amount for which the price will be fixed by a specific date. Now, both of these contracts had been performed with no problem. The only difference really with the 2018 contract was that it was over a longer time period. In the judgment, the court gave a useful walkthrough of case law on this subject, starting with a case called May and Butcher from 1934, which sets out the principle that if price, being an essential ingredient of a contract, is left to be agreed later, then there's no contract. In that case, the purchaser agreed to purchase all the seller's tentage, which might become available during a certain period at a price that, quote, shall be agreed from time to time. However, the court was keen to point out that there are a number of subsequent authorities where the courts found a contract had been enforceable even though the price was subject to further agreement. It was a question of construction. Not agreeing a price up front may show no intention to be bound, but it didn't necessarily do that. There were instances where, on construction, it was clear that the parties had intended to enter into a binding contract, but future prices were left to be determined. Relevant factors when considering this question were the history of dealings between the parties. So in this case, there had been a history of dealings between them, and it had all been okay. Whether the document looked like a formal contract, whether the parties were dealing in trade that they were familiar with, well, in this case they were. And in cases like that, the court would be willing to imply terms to give effect to the binding bargain the parties had entered into, such as implying terms that a reasonable or fair price or market price should be paid. And Section 8 of the Sale of Goods helps as well, because it says that the price in a contract of sale can be fixed by the contract or can be left to be fixed in a manner agreed by the contract. You sometimes see that, don't you, with like a formula or tracking of an index or something, or may be determined by the course of dealings between the parties. But if none of those helped to determine the price, then the buyer had to pay a reasonable price. But the court couldn't use reasonable price if the contract said something else about how the price was to be fixed. And if the parties were entirely free to agree or disagree about the price, then a term on price couldn't be determined, and it would be likely to be an agreement to agree and not a binding contract. So the court decided that because this contract did not say how the price was to be fixed, then Sale of Goods Act Section 8 would help and imply a reasonable price, even though it actually did find that there was an implication that the parties would reach an agreement because of this wording that had to do with the agreeing of how many free tucks of product. So the fact that there would be an element of agreement wasn't fatal to the fact that the court could apply a reasonable price. On the facts, the court found that the parties had intended to enter into a binding agreement. This was because there was a 3-year term. They said, we will buy this much product over 3 years. They had agreed a sort of notional price, although it would be subject to some movement. The court preferred to look at the contract as an agreement to pay a definite lower amount for the volume, even though this could be changed by this addition of free trucks, depending on what the final price was fixed at. The parties had entered into similar contracts before and agreed the price successfully, which was the usual thing to do with a long-term supply agreement, especially in a volatile market like this one. So it was a binding agreement. Therefore, the court would seek to give effect to it and imply a term on price. And it decided to imply a market price. And there'd been a lot of evidence in the case given on what that market price might be. And in the end, the experts agreed that the price for these Wessos was actually tagged to the price of another product which was publicly available on an index. So what to take away from this Well, the thing that I took away from it, this isn't the court's judgment, but if only they put that formulation in about it, the fact that it tracked an index, that would have been a really easy thing to do. But I guess that's much easier to say with retrospect and hindsight than it would be at the time. The other thing is to take away from it is that it is okay to have pricing flexibility in a long-term supply agreement. Now, the wording, if you read the actual wording of the clause on price, it's very, very brief. It's not at all clear. It's probably one of those where everyone involved understands a lot about the market already, so that they kind of take for granted a lot of the meaning. So just having clear wording in the contract to say how that is going to be fixed would have been really helpful in this case, and it might have meant they didn't end up going to such expensive litigation. Okay, so that's where I got to with that one. Can I have the next slide, please? Thank you. So the other cases I'm going to talk about today concern third-party rights. And there do seem to have been a few cases on these recently. If you were here last time, you might remember that we looked at the DEFRA case from the Supreme Court, which concerned the commercial service union's right to benefit from a term in the employment contracts of various workers. Well, this time, the cases were slightly different, but also again to do with third-party rights. The first case, Francis Joseph Campo and Gotex Real Asset Fund, 1 OE Waste Sol, it's a long name. In this one, Mr. Campo was a director of a company that was purchased by OE Waste Sol, and he was also head of an advisory team which provided advice on the transaction. There was an SPA detailing the sale, and it said that each of the warrantors undertakes that it will not, and will procure that none of its affiliates will, bring any claim or other action in respect of negligence or otherwise against any target company or any of their respective directors, etc., in relation to any matter arising out of or in connection with the transaction document. And the clause also made it clear that it was intended to benefit the third parties named for the purposes of the Contracts Rights of Third Parties Act. So Mr. Campo, having been a director, should have been protected from any claims relating to those transaction documents. And the third party rights clause said that except as expressly provided in this deed, a person who is not a party to this deed will have no rights under the Contracts Rights of Third Parties Act to enforce any terms of or enjoy any benefit under this deed, which is a fairly standard third party rights clause, isn't it? The agreement was under English law with an exclusive jurisdiction clause for England and Wales. However, OE Waste issued proceedings in Luxembourg that Mr. Campo had acted negligently or in breach of duty, with the result that the company had been sold at an undervalue. Mr. Campo objected to proceedings in Luxembourg and brought a claim in the English courts to enforce his third-party rights. But OE Waste applied in England to set aside service, saying that Mr. Campo couldn't rely on a jurisdiction clause in an agreement he wasn't party to. So the issue was whether or not Mr. Campo could rely on the exclusive English jurisdiction clause, even though he wasn't a party to the agreement. So the court said this was a matter of construction. So OE Waste pointed out that the indemnity specifically referenced the rights of third parties. So it specifically said that the third party was to benefit from it, and it pulled in the Contracts Rights of Third Party Act. But the jurisdiction clause didn't say anything like that. And what OE Waste said is, with the drafter obviously had third parties in mind, so wouldn't they have made specific reference if that exclusive jurisdiction clause was to cover third parties too? Now, what did the exclusive jurisdiction clause say? Again, fairly standard, I think. It said each party, obviously Mr. Campo is not a party, irrevocably agrees that the courts of England and Wales will have exclusive jurisdiction to settle any dispute which may arise out of or in connection with this deed, including any dispute relating to any non-contractual obligations. And the court said that this wording was wide enough to cover claims by and against third parties. The parties couldn't reasonably have been understood to have agreed that warranty claims ought to be dealt with in different courts. And it said this was the common sense view. However, it is a really interesting point, because even though this is what Mr. Campo wanted in this agreement, and it was to his benefit, making a third party subject to an exclusive jurisdiction clause does risk straying into territory where a burden rather than a benefit is placed on the third party rather. So he hasn't agreed to be bound by that exclusive jurisdiction clause. But if the facts had been different and he didn't want to be bound by it, would he have wanted that burden to comply with that exclusive jurisdiction clause? Would he wanted to have that placed on him? So it was only a High Court judgment, and there may well be more commentary on this subject. Can I have the next slide, please? Thank you. Okay, so the next case that I'm going to talk about is a case between HNW Lending Limited and Miss Nicholas Stacey Ann Lawrence. So again, this is another question about third-party rights in contracts. So HNW is an FCA authorised peer-to-peer lender. And what it does, it arranges loans from lenders to businesses. And Miss Lawrence was carrying on a business as a property investor, and she had a portfolio of 10 residential properties. She wanted to develop these properties, and in order to do so, she needed some money. So in a series of different agreements, she borrowed around about £3 million from the lender to complete the development of these properties. Now, the loan agreement named HNW Lending as the security agent and said this: the lender authorises the security agent to perform the duties, obligations and responsibilities and to exercise the rights, powers, authorities and discretions specifically given to the security agent under or in connection with the finance documents. And it also said that the borrower and lender agree that while HNW Lending Limited is not a party to the loan, it may take the benefit of the agreement and enforce each express term of it, pursuant to the Contract Rights of Third Parties Act. Now, it's worth noting in this case that Miss Lawrence acted as a litigant in person. She made all sorts of claims and accusations to try and get out of paying this loan back, to paying the interest back. She claimed that she'd been subject to undue influence. She claimed that documents had been forged. She claimed that she hadn't realised she had to make a monthly interest payment. She contradicted herself in the submissions and then in her witness statement. So I don't think the court found that she was particularly credible, and that may be worth just bearing in mind as well in this one. The only serious legal point was her argument that HNW, because it wasn't party to the agreement, didn't have any standing to bring the claim. And in doing so, she relied on a county court judgment that had already been made against HNW Lending on that point. And that case seems to have been a bit better argued. That person was probably represented, I think, and because some paragraphs of that judgment are set out in this case. But nevertheless, the judge in this case said that the judge in the previous one had come to the wrong conclusion because he hadn't given proper consideration to the Contracts Rights of Third Parties Act 1999, which provides at Section 1. So this is something that I'm pretty familiar with, and I'd never really thought of it in this way until I read this case. So it is quite interesting. So what it says is, subject to the provisions of this Act, a person who is not a party to a contract may in his own right enforce a term of the contract if A, the contract expressly provides that he may. Well, that was met, wasn't it, in this case? Or it purports to confer a benefit on him, as in with Mr. Campo's case before. Now, what the court said is that the loan agreement had clearly been drafted with Section 1A in mind. It expressly provided that HNW may enforce the contract. But the judge pointed out that there is a lack of case law in this area. And in this case, the contract did make an express provision. But in enforcing the contract, HNW wouldn't be doing so for its own benefit, but for the benefit of the lender. So the court had obviously found, well, we think there was definitely a bargain between these parties, and we want to give effect to it. And this was a way to achieve it. No one appears to have advanced any arguments on agency, because I thought if they'd acted as somebody's agent, then perhaps the third party question could have been overcome that way. But it is an interesting point, because I think when I'm considering third party rights in a contract, it's usually with the idea that the party is expressly mentioned so that it can enforce clauses which confer a benefit of it, like in Mr. Campo's case, but also in the case of maybe a TUPE indemnity for an incoming supplier or something like that. So this case, the lady was given leave to appeal on the basis that there is no binding case law in this area. And now I'm going to hand back over to John.
Thank you, Rachel. Some very interesting points there, specifically to us commercial lawyers. Can I have the next slide, please? Thank you. I'm going to quickly run through what's been happening in the world of data protection, and as you may have noticed, it's not been a quiet period. We've had a new act. We've had some fairly highly publicised data breaches, cyber attacks and data breaches, and we've also got in the background an active regulator holding our feet to the fire. So we'll run through all that. We'll start off with the new act. Now, when we last spoke, I think it was probably towards the end of May, I think this was about to actually get royal assent. So we knew pretty much where we were back then, and we went through it in some detail. So I won't go through it in the same detail that we did last time, but I will go through some of the key issues. The Act, the Data Use and Access Act, got royal assent back at the end of June, and it has brought in some significant, albeit not sort of epoch changing in the same way as GDPR type changes. And the reach does reach across UK GDPR, it reaches across the Data Protection Act, and it reaches across the PECR, PECA. So just running through, what do we have now that we need to be aware of? Well, we've got a non-exhaustive list of legitimate interests, which is helpful, because previously it was never quite clear what could or could not be a legitimate interest. Helpfully now we have direct marketing in there, and we have group transfers. So we can rely on those, although when you do rely on those, you've got to carry out your legitimate interest assessment just to make sure that your rights balance against those of the consumer of the data subject. So always need to have that just for the purposes, at least, of your audit trail. We have a list of recognised legitimate interests where you don't actually have to go and carry out your balancing exercise, where the ICO will recognise that this is a lawful use of data, but it's pretty specific and pretty limited. It's in the grounds of national security, public security and defence, responding to an emergency, detecting, investigating and preventing crime, and safeguarding vulnerable people. So focus very much there on public sector and national security type grounds. So I suspect that for most of us, that's probably not going to be particularly applicable a lot of the time, although safeguarding vulnerable people and responding to emergencies, though we can see situations where right across the private sector that might apply. For example, if you need to give out data of, you're holding data, for example, of someone whose welfare you might be concerned about, and you want to pass that on to the relevant authorities. A complaints process for data protection complaints by data subjects. Now have to have one of those in place. So that's one for the to-do list, although not quite yet. The ICO has proposed draft guidance, so go on their website, have a look at that. They're taking in consultation. At the moment, it looks pretty reasonable. I'd be surprised if it changes much. It's essentially the kind of thing you'd expect. If you get a complaint, you've got to respond within 30 days and have a process for that. So yeah, so a policy to add to the policy bundle there, I think, but one that can largely, I think, for most of us, look like the one that the ICO recommends. We also have some helpful wording, or potentially helpful wording, in relation to subject access requests, which I'm sure all of us deal with. We now have, when we carry out searches in response to a DSAR, these searches are clarified as having to be reasonable and proportionate. So you don't have to go to the nth degree to find data. I think some of the key problems still remain. So, for example, if you have a data subject who will not prune down the scope of their request, who just wants everything, I think you're still going to end up with a fairly large exercise. And to that extent, I don't think that I don't think our lives are suddenly going to get a lot easier. Next slide, please. Thank you. The ICO is going to be restructured and renamed as the Information Commission. I'm not entirely sure whether this will have any significant effects. We're going to start noticing a rebranding exercise, I think, probably from early next year. But we'll just have to wait and see whether it really makes any changes in terms of the way it's governed and the way it behaves. Cookies. Again, sort of a lack of, it was I guess, a consciousness that the law really wasn't reflecting the practicalities. The law has gone a little towards making our lives easier. It now allows businesses to use cookies without user consent in certain restricted cases, so for statistical or performance cookies. So you don't actually go and have to get the express consent in these cases, but you still have to inform. So you're still going to need to see those pop-ups and allow opt-outs. So there's probably a need there for an analysis of your cookies, liaise with your IT departments, and see which ones can be moved from consent to information only. So might make things a little bit easier. And then finally, we have monetary penalties are going up. They never go down, do they? The Information Commissioner has suffered really from its inception with the bad case of penalty envy. It always thought that its penalties and the tools at its disposal weren't quite as good as those as their colleagues in financial services and competition, and also in particular in relation to direct marketing, which was an aspect that they're really concentrating on. They didn't feel that the penalties at their disposal were sufficient, so those have now gone up from £500,000 maximum up to the same limits as in the rest of UK GDPR. So we've got about 4% of annual global turnover. So just to be aware that that we're likely to see those now significantly growing. Next slide, please. So I guess moving on to sort of the real world environment, we had a report from the National Cyber Security Centre back at the end of August, which told us what I think we knew already if we'd been following the media, that there'd been a dramatic growth in malignant cyber attacks across industry. We've seen a rise from 89 in the year 2024 up to 204 nationally significant cyber attacks. So this, I think that kind of figure alone means that businesses need to be waking up, looking at what they're doing, and significantly increasing budgets. And I guess from our perspective as in-house counsel, these are data breaches. So they're dealt with under the umbrella of at least under the umbrella of the data protection legislation. But as we'll see, they also have very, very significant economic and financial implications as well. And we'll look through what's some of the ones that are happened recently, some that are ongoing, and and we'll also have a look at an investigation and finding by the ICO into one that happened back in 2023. Next slide, please. So yes, you're probably aware, I think, of some of these. I mean, we've had 3 very significant ones this year, starting with this Marks and Spencer attack, which started in April of 2025, described by the industry as a highly sophisticated and targeted incident. So very technically proficient, if we can describe it as that. Astonishing, really, that it came down to, it looks like it was a phishing attack on an employee at a third-party vendor. So, you know, an email sent with a link that someone clicked. So it wasn't even M&S itself, but it was one of their consultants, and that person had been given access to the M&S systems, and it then managed to get details of login details for those employees, and they were into the M&S system. It closed down the entire M&S digital sale system for a number of weeks. So very, very significant impact on online sales. They're still ongoing with it. They're still getting back to normal, but at this stage, financial impact estimated as being in the region of 300 million. Next slide, please. At the same time, and if reports are to be believed, potentially involving the same persons, there was a very significant cyber attack on the Co-op Group. Co-op Group, of course, is a membership body with a very large national and international membership, and this attack resulted in a very significant data breach, with the hackers getting their hands on details of all 6.5 million members of the Co-op. And this included sensitive data, names, contact details, birth dates, etc., but not, I understand, financial details. So there was the Co-op systems were able to prevent financial details getting out, but all the same, still at the high level of seriousness. And as with M&S, of course, widespread operational disruptions, empty shelves, inability to process payments, etc. And again, financially, pretty nasty stuff. Loss is estimated at this point, again, relatively early, of £206 million. But those two, Co-op and M&S, now being resolved. We do have one attack that we know is ongoing. If we move on to the next slide, please. And that's, of course, one that you'll also probably be aware of, which has had very substantial, potentially national economic implications, which is the attack on JLR, Jaguar Land Rover. Has resulted in a shutdown of its global IT systems. We believe it's a ransomware attack, and there's again, we don't know the full details, but serious personal data theft. Significant impacts here, not just on JLR themselves, but also on their suppliers and customers. Again, the figure touted at this stage, 300 million. So fairly sobering stuff. And again, these are the headline grabbing things, but as the report I mentioned at the beginning showed, these attacks are not just at the high level, they're at the sort of small and medium level as well. They're right across the board. What is the ICO doing? Well, there will undoubtedly be very detailed investigations of these 3 incidents by the ICO. And we know now what those are going to look like, because yesterday the ICO published their report into a very significant data breach that occurred at Capita. And we'll have a quick look at that. That's on the next slide, please. Thank you. This was a hack and a data breach that took place back in 2023. And we got the full, as I say, the full report yesterday, which has shown that a couple of Capita Group companies have been fined a combined £14 million, which is, I guess, fairly eye-watering. But if we look at the history of it, the original proposal by the ICO was that they were going to fine Capita £45 million. So that was reduced. So that has been significantly reduced. So there is some positive news for Capita there. And we can see that there was actually I guess a negotiation between the two parties, but also Capita's IT team were able to, I think, do some pretty valuable work by being able to demonstrate to the ICO where they had been, they couldn't have been to blame. So that has been very important. Being able to show that that audit trail has been very important in reducing a £45 million fine to a £14 million fine. So I think that there is a report, a detailed one, which is on the ICO's website. I would strongly suggest printing it off or and reading through it, and also sending it to your IT teams, because it's it's interesting, both in how they managed to both in how the cyber attack worked, and also some fairly sobering stuff in there about how it happened. So, for example, the Capita IT teams were aware of the attack happening, but they weren't able to stop it. So it went on, you can see, for a total of nearly 10 days, from the 22nd to the 31st of March 23, and again 6.5 million individuals, lots and lots of information, including sensitive data, special category and financial data. So again, right at the upper level of seriousness. Capita didn't manage to get their systems back into order until the 17th of May. So this is a really significant incident, and we can see then that having got the systems back, they've then got the joys of dealing with the ICO. And just to cap it off, they've now got a multi-party claim as well from nearly 4,000 named claimants, which will no doubt take a significant time to be resolved. Okay, next slide, please. Just a couple of smaller things that probably worth mentioning. I often get asked what happens if we don't respond to a subject access request. Do we have to always respond to these? This case here, the one of Jason Blake, shows, albeit at a small and low scale, low level, what was happened. Here we have a request from the daughter of a resident at a nursing home for fairly reasonably innocuous personal data. The nursing home didn't respond. We're not quite sure why. They never gave an explanation as to why. And of course, the claimant got fed up of waiting, complained to the ICO. The nursing home didn't give them an adequate response. And of course, it all ended up in the magistrates' court with a fine reasonably low level, just over £1,000, but not insignificant legal costs too. So the answer there, I think the lesson, if we didn't already know it, is that if you get a DSAR, well, the answer is you have to deal with it. Next slide, please. And another one just on a much larger scale of failure to deal with DSARs, this time Bristol City Council. And this wasn't like the sort of, I guess, the sort of bad faith type issue we had previously. This is one where Bristol City Council were basically overwhelmed. They had lots and lots of DSARs, and they just weren't of a level of staffing to be able to cope with them. There were 63 separate complaints to the ICO. The ICO got involved and said initially they seem to have dealt reasonably sympathetically with Bristol, because Bristol were holding their hands up and saying, well, we're short of money, we're short of staff, we can't deal with this. So the ICO liaised with them, but said, you have got to deal with this. And they've issued an enforcement notice which sets out timescales for dealing. So they haven't fined yet, but there's some fairly clear timescales, and we have a backlog going back to 2020. So if we think that you're supposed to be dealing with these in a maximum of 3 months, we can see perhaps the level of the problem there. So I guess we will see. We will keep an eye on what happens with that. I think we wouldn't be surprised if these are not complied with. So we will need to see what follow-up action, if anything, we see from the ICO. So as you can see, yeah, lots going on there. So yes, if your board asks you for a review of what's happening in the world of data protection, I think you can say, well, it's not been quiet. We've got a new act. We've got a very difficult threat environment, and we've got an active regulator. So yes, lots to think about. So on that note, if I could then hand over to my colleague Roxanne, who is also going to take us through events in the world of business immigration, which again has not been quiet. Roxanne.
Brilliant, thanks John, and thanks for inviting me to speak at this quarterly update. So if I could have the next slide please. I'm going to start off with a shameless plug of who we are within the Napthins group. So helpful to have always nice to put a face to a name, so there you go, there's us three who make up the business immigration team within Napthins and the AfterAthena company. So it's headed by Angela. I sit in that team, and my colleague Kajal, who is also on this call, comprise the rest of the team. Myself and Angela are actually employment lawyers as well, so that's quite a nice interplay between certain queries that come our way where it does have the employment and immigration elements both to it, and Kajal has that sole immigration experience as well. So our contact details there. I appreciate I'm just going to be doing quite a quick whistle-stop tour of the changes which have happened this year, and there has been a lot of movements similar in the data protection world, but yes, definitely the business immigration world has not been quiet, especially from May this year. If I could have the next slide as well please. Okay, so 2025 then, yes, it has been a busy year so far. So we're going to kick off with the immigration white paper titled Restoring Control Over the Immigration System. So this was published in May of this year, and the main aims of the white paper was to reduce the net migration and end reliance upon overseas labour. It's no secret that the government have a particular focus on migration to the UK and immigration in terms of getting those numbers down, and we do see it across the media pretty much almost on a daily basis now in terms of those proposals. So the main proposals that were stemming out of that immigration white paper was that the regulated qualifications framework, otherwise known as the RQF level for roles, was going to be raised, and I put there in brackets back to level 6 because that did used to be the prior position prior to Brexit. And then obviously Brexit happened and a lot of sectors were finding it very difficult to recruit into. So the government actually lowered the skill level for roles which were eligible for sponsorship, but now it's gone back up to 6. And the level 6 pretty much is like a bachelor's degree with honours type level. So it's just something to be aware of. Also, it's not the actual individual who's assessed, so you're not sort of bound by having to have an individual who only has that degree who's able to perform that role. It's actually the skill level of the role itself, which has to be at that particular level. There's also removal of over 100 occupations from the list of eligible roles for skilled worker sponsorship. We do tend to get different numbers floating about how many have actually dropped off the list. I think at the moment it's between 110 up to 180. I've not personally counted all the roles that have dropped off that list, but it's somewhere in between there. There's also the creation of a temporary shortage list, and that sits alongside the current immigration salary list. And again, it wouldn't be changes without looking at salary thresholds, and those are probably being increased by the government as well. In terms of the occupations where we have actually seen the removals, it tends to be around about sort of like chefs, bar managers, bricklayers, carpenters. We've seen those types of particular roles actually drop off. But again, it's to be reviewed by the government. It's likely that it probably will be reviewed again towards the end of this year as well. Could I have the next slide, please? Okay. So then after the proposals came in and shook everyone up as to what was going to happen, the statement of changes came in on the 1st of July this year. And these set out sort of rules which were going to apply for any certificates of sponsorship which were assigned on or after the 22nd of July this year. If a cause had actually been assigned prior to that date, the rules which applied at that time would then continue to apply, even if the visa is then sort of decided and secured after that particular date. If the employer already holds a skilled worker visa, there is no immediate impact, but they will need to meet the new minimum salary requirements if they extend, change roles or change employer. There was no transitional sort of arrangements in respect of that salary for that. If we do have individuals who are currently on a skilled worker visa, there were a few transitional arrangements in respect of allowing them to be able to extend their visas and also bring dependents and change employment applications if they are already on that route. Because of the proposed changes that have come in and which have now been implemented, due to reclassification of roles, many are now shown on the particular list of eligible occupations as either medium skilled, higher skilled, or ineligible for sponsorship. So that has had a massive shake-up. So one point that I would say in terms of business is any roles that you are thinking of sponsoring an individual in is just to be checking those eligible occupations again, because roles that you may have previously been able to sponsor for, you might not be able to do that anymore. Could we have the next slide, please? Okay, so I mentioned the temporary shortage list. So this is going to run alongside the existing immigration salary list. This does include occupations now which have been reclassified at RQF level 3 to 5, and that's been identified by the Treasury and Department for Business and Trade as important to the modern industrial strategy, which the government are putting forward. I've got a note on there about applicant beware, just in terms of roles which are sponsoring via the temporary shortage list. For new applicants, you can no longer bring your dependents with you on that role. And also there's no provision for a discount to the salary or lower visa application fees just by fact of the role being on the temporary shortage list. And this list, it will eventually replace the immigration salary list. So currently the immigration salary list, if you do have a role on there, you might be eligible for some type of discount that can sit alongside that. But if the role that you're being sponsored for only features on the temporary shortage list, there isn't one. However, you can actually combine a role which features on the temporary shortage list with any other sort of tradable points, which then allow a discount, such as new entrant discount rules. Currently, you can sort of couple that up. So what influences what roles are placed on this temporary shortage list? So in summary, it's you guys. So the Home Office do encourage reporting and engagement to develop workforce strategies in certain sectors. And if there is a gap and enough businesses within a sector report particular concerns, then roles may feature, it may be added onto the list. Same way as roles may be added onto the list, certain roles may also be removed. So it's not sort of a set in stone type of list. It will constantly be reviewed, and the only way that sort of the Home Office then start implementing that is obviously by businesses sort of being vocal about where their recruitment concerns are and what they're actually facing. I've got a note hot off the press. So at a recent conference that we attended, immigration practitioners have reported actually seeing a decline in sponsorship in certain sectors where there is going to be this reliance on the temporary shortage list. The reasons that are being reported for this is that it's due to the current rules that you can't actually bring the dependents. Obviously, that is a big one here, where often individuals who are being sponsored in their own right as skilled workers may have a spouse, may have children, that they do wish to bring across with them whilst they are working here in the UK. But because of the uncertainty of that and particular rules around not being able now to bring dependents if the role is on the temporary shortage list, we're sort of seeing sponsors backing away from this. Also, there's some uncertainty as to whether, if, for example, an individual was sponsored for a certain period of time, wasn't the full 5-year period, and then they needed to extend their current permission in the UK with the reliance on the temporary shortage list, it's whether the role would still be on there or not if, you know, this list is consistently reviewed and roles keep dropping off or being added onto it. So that's another reason why we're actually seeing that decline. The intention is that the temporary shortage list addresses gaps on a short-term basis and allows employers to upskill workers to reach the RQF level 6. So it's not seen it's not intended as a pathway for younger migrants sort of to enter the workforce by utilising any type of discounts to it, which is why I believe they've set it up the way that they have. Next slide, please. So increase to salary levels then. You can almost guarantee every time that the Home Office start reviewing this, there's going to be some type of increase on salary levels somewhere. So these do apply from the 22nd of July this year. So the minimum general salary threshold has actually increased now from 38,700 to 41,700. It is important that when you are looking at salaries for skilled workers, that you are also checking the relevant going rates for the role that you wish to sponsor for, because you are generally required to pay the higher of either the general threshold that applies or the relevant going rate. The minimum hourly rate has increased from £15.88 to £17.13. And again, going rates specific to that role have also increased on that table. Discounts are still available. So the lowest salary available is £33,400 from 22nd of July. That is an increase from the £30,960, which was the base level if, for example, you were relying on a new entrant discount. Lower rates do continue to apply for those who have had a certificate of sponsorship and have been on skilled worker visa since before the 4th of April 2024. So that general threshold used to be 29,000. That has slightly increased now to 31,300. But that 4th of April 2024 date does feature quite a lot across the board in terms of skilled worker sponsorship, because it is quite a key date in terms of what types of salary is going to be paid. So for example, the going rates table, some of you may have noticed it's split into lower going rate and standard going rate. The lower going rate column will apply if someone has had a COS before the 4th of April, or if they're being sponsored in some certain health and care sort of sector roles. Albeit after that, if the COS was issued after that, then it's the standard going rate, which is an increased amount. For those extending or changing the visas after the 22nd of July, the increased salary requirements will need to be met. Again, there's no transition there to allow them to sort of freeze the general threshold at the time. So they will need to meet that. So that is important for you to understand in terms of your recruitment practices. Next slide, please. And then earned settlement. So when these proposals all came out and they were kicked off from May, there was mention here about increasing the qualifying period for indefinite leave to remain. So that's the way that a migrant worker can settle in the UK. So currently the qualifying period is 5 years. However, the government are proposing to double this now to 10 years before indefinite leave can actually be achieved by such individual. It is likely that there's going to be some exceptions to the increased period. However, in order to achieve any of those exceptions, it is likely that it's going to be centred around contributions that the migrant worker has made to the UK economy. So whilst the white paper and the statement of changes acknowledge proposals for doubling the qualifying period before indefinite leave to remain can be achieved, we at this moment in time have yet to have a clear guidance on how it is going to operate and what level of contributions will actually reduce the qualifying period and by how much. The initial intel is that it's going to be based around sort of national insurance contributions that the individual pays from their salary by way of PAYE, etc. And also that they're not relying on sort of state benefits, so they might get some type of credit for that off any future qualifying period that they need to meet. We understand from the conference that UKVI, so the Home Office, they're going to be hosting a series of webinars by their communications teams over the next forthcoming weeks, which will also cover off any discussion regarding settlement requirements, but naturally is quite an unsettling time for individuals who are currently on the route towards qualifying for indefinite leave to remain as to whether the rug is going to be pulled from underneath them effectively, and whether they're then going to have to be sort of staying here for a further 5-year period of time to reach that 10-year qualifying period or not. Next slide, please. And then just when you thought things could get even more exciting, there was another statement of changes which has just been published this week, so the 14th of October. So key points from that in terms of sort of skilled sponsorship. So from the 8th of January, 2026, skilled worker applicants will need to meet a higher level of English language proficiency. So it's going to go from a level B1, which is a GCSE level of English, to the higher level B2, which is A-level requirement. So that's going to apply to new applicants on that skilled worker route. It's not going to impact individuals who are already in the skilled worker route as of the 8th of January 2026, when they then come to extend their current permission. Immigration skills charge is going to increase by 32%. So it's not a small amount that's going to increase by. That's the levy which is imposed on sponsors for having the benefit of sponsorship, and that is payable at the moment that you assign those certificates of sponsorship. So that is going to increase. Again, that's one just to be wary of in terms of your recruitment practices and your budgets. And then finally on that one of the key changes that is coming in is that from the 1st of January 2027, the graduate visa route period will reduce from 2 years to 18 months. So that's quite a popular unsponsored route at the moment for students who are in the UK, who want to remain in the UK, but then they'll switch across into the graduate route for a further 2-year period, and then in the hopes that they then obtain sort of skilled worker sponsorship. A student can actually go straight into a skilled worker sponsorship, but I think the trend that we tend to see, or that I've necessarily seen, is that they try and extend out that unsponsored time in the UK and then decide to jump across. Whether these proposals impact that, we might see more applications where students are just going straight into the skilled worker route instead. There were other changes that have also come out from that statement of changes, and that includes general grounds of refusal. The mandatory grounds of refusal across all immigration routes have been replaced by a new sort of part suitability requirement. So if you do fall down on one of those conditions, it's likely that the application would be refused on suitability grounds. And also other changes that have come in is the high potential visa eligibility is expanding. So more university institutions are being added to that particular route. However, the government is going to cap the number of applications per year at around 8,000 on that as well. Next slide, please. Final one from me. So what should you do as a result of all these changes? So there's a note there just to say the Home Office, they are showing the teeth with compliance enforcement against sponsors who are not adhering to duties or reporting in line with what they're supposed to do. They are very interested in right to work checks, and that's always going to be an area that the Home Office will have a look at if they ever did come out to visit, if there was any type of compliance check. And salary, that is also paid. And it's just a note there as well, just to let you know that the government departments, they do communicate with each other. So for example, if you've had HMRC in where there's been a complaint as to whether you're paying the national minimum wage, for example, or whether you're adhering to sort of working time, etc., the government departments, they do all talk to each other. So the Home Office would be very interested if they were aware of an investigation being conducted by another department of the government into your business. So it's just something to be wary of. I've got a note there, internal auditing will be your best tool to identify any problem areas. That's going to be your first port of call, just having a look inside and seeing, okay, what's going on in our business? Where is it that we could identify any problem areas, and what remedial action can we take before, any type of action is taken against us, or if we do need to raise it to the attention of the Home Office at that point. And then just review your recruitment processes, understand the rules and changes, which is probably not the easiest feat to do, considering it changes quite a lot, and budget appropriately for that recruitment. And what I would say, even if you're not a sponsor, if you are thinking of this at some point in the future, then again, you might just want to have a look at what the requirements are, just ensure that you have the appropriate HR processes and systems in place to be able to meet those sponsor duties, because that's going to stand you in good stead when you then come to make that application, if you did want to do that. And I think that was it from me in terms of a whistle-stop tour. I think the next slide just says, is there any type of questions, I think, from this webinar?
Thanks, Roxanne. I think we did have a question, but I think looking at the chat, I think that it's been answered.
I've just answered it.
Yes. So no, thanks for that. Again, a sort of an excellent summary. Again, probably just remains for me to just thank everybody for joining us. I hope that was useful. It's not been a quiet quarter. And I suspect that the next quarter may not be quiet either, which is why we will be aiming to catch up again probably early January with everybody. Very much hope that you'll be able to join us again then. If that's not enough, we'll be sending out a further just summary of changes as well, probably in about a month and a half's time, just to keep you up to date. And we'll also send out a recording of this session as well. So just in case you missed anything or there's anything you're worried about, then we'll be sending that through. So thank you very much as ever for joining us, and we hope that was useful, and we hope to see you all again very shortly. Thank you.